Okay, hello everyone. My name is Andrew Kaplan and I head up Pierce Atwood's Energy Storage Practice Group. The lawyers in our group have been focused on energy storage matters representing project developers and trade organizations all over the country since 2006. Our group consists of lawyers who specialize in energy, environmental, real estate, land use, transactional, corporate, tax, and IP matters. Given this broad range of expertise, we offer so-called one-stop shopping for an energy storage project developer. And today I, along with my colleagues Dan Bailey, Tess Edwards, and Nick Salaleco, will walk you through the storage siting aspects of the Clean Energy Bill. I should point out that even though I had a hand in drafting this legislation, when the process involves hundreds of people with diverse professional experiences and personal experiences, backgrounds and constituencies, you don't necessarily wind up with a perfect product. And this act does a lot, but it can also be a little confusing at points. Sometimes it's inconsistent. And while we will point out those inconsistencies, we really want to focus on what a BESS developer who needs state approval of their project by Q4 2026 needs to do now. We'll also spend some time talking about what happens after that, but we're going to try to focus on the next couple of months and what you need to do. So the governor signed the Clean Energy Bill into law on November 20th. And despite the length of the law at 130 pages and the complicated intricacies within the law, the goal of the legislation was to streamline the permitting process. In particular, the permitting process for energy storage projects was in a bit of a flux in Massachusetts. The first two large battery storage facilities are now being constructed in Carver and Medway, Massachusetts. And at the time that we proposed these projects for siting, the Commonwealth wanted the Energy Facility Siting Board to have authority to review the projects. However, during that process, we had a change in governor and a change in administration. And after we went through the entire process, the new administration determined that they did not have jurisdiction to oversee the project. And this was because in 1973-ish, when the siting board legislation was last drafted, only generating facilities could come before the EFSB for review. And Massachusetts had determined that energy storage is not a generating facility. So the project was deemed to be not jurisdictional by the EFSB. And this meant that the storage projects had to go through a number of hoops to get approval and remained at risk for operations to the whim of a local municipality or abutters that really weren't that interested in working with the developer to perhaps move or improve the facility, but instead only wanted the project away from their backyard. So with respect to energy storage projects, this presented a problem for the Commonwealth. On the one hand, the Commonwealth's policies made clear that we want and need energy storage projects to be developed. On the other hand, the permitting process was scaring off some developers who found it easier permitting process in other states. So this law is designed to make the permitting process for energy storage more palatable in the near term and also going forward long term. So first, it divides the project based on size. Smaller facilities, those under 100 megawatt hours, have one permitting process, while large facilities, those 100 megawatt hours or more, have another process. And we will go into those in more detail a little later in the presentation. Another goal of this law is to advance equity. There's an environmental justice aspect of this legislation that will protect overdevelopment in communities that have been deemed to be environmental justice communities. And there's also a funding mechanism embedded in this law in an effort to mitigate the delays of the permitting process that is often created by NIMBYs or the not in my backyard folks. The legislation provides a funding process for approved interveners. Although it sounds daunting, these processes are in effect legal proceedings, and if the intervener can retain legal expertise on siting matters and even experienced consultants to assist in the process, the intervener will be better able to impact the project in a positive way, as opposed to merely opposing the project based on fears spread on social media and delaying the permitting process because you have inexperienced people participating in a legal proceeding. So while I know there are some developers who fear the funding of interveners, I see it as a positive step for developers and interveners to work together in a more collaborative fashion, or at least present coherent messages to the state agency that needs to make a decision on whether or not to site the facility and under what conditions. The requirement to implement an intervener supporter fund is not effective until 2028. So if you want to get in before that, that's what this topic of conversation today is more focused on. So today we're going to focus on two processes for energy storage. The first process is for those developers who are looking to have all their permitting in place by Q4 2026. And we'll sort of talk you through what you need to accomplish between now and March 1st-ish, 2026, in order to get a certification from the EFSB to construct your facility. And with the deadline of March 1st, 2026 to petition to go to the EFSB, we need sort of a schedule working backwards on what you need to do starting in Q1 2025 to meet that 2026 deadline. And the second process is for those developers who don't need approval to construct the project until 2028 or 2029 and are willing to take some risks to participate in a regulatory process that hasn't yet been developed. Next slide, please. So part of the new law becomes effective February 19th, 2025. So under the current law, a developer may seek an exemption from local zoning bylaws by filing a petition at the DPU. So this chart depicts a filing of a 40A zoning exemption for large and small energy storage developers at the DPU through February 19th, 2025. After that date, a developer can and should file for a zoning exemption from local bylaws, but where to file that petition is a little confusing as it is written in the law. One section states that effective February 19th, the zoning exemption should be filed at the EFSB, while another section seems to require filing at the DPU. So we need to sort of sort that out. But the bottom line is that a large facility of 100 megawatt hours or more that wants to get a certificate of environmental impact and public interest from the EFSB, which replaces the need to seek any remaining state, local, or regional permits, need to receive approval of a comprehensive zoning exemption by the time that the new regulations for the future EFSB agency are promulgated, which is March 1st of 2026. So knowing that you need an approved comprehensive zoning exemption by March 1st, 2026, so that you can file for a certificate between March 1st and July 1st, 2026. I know this sounds complicated and ridiculous, but it means that you must file for your zoning exemption in Q1 2025, as it takes 9 to 12 months to receive that approval in a good year. Next slide, please, Nick. After the new EFSB process is implemented, which appears to be slated for July 1st, 2026 under the law, small storage facilities which are under 100 megawatt hours can seek a certificate from either the EFSB or local permits. And large storage facilities of 100 megawatt hours or more have to seek a consolidated permit from the EFSB. Next slide, please. So in accordance with the new law, any storage facility that wants a certificate from the EFSB to replace the need for local or other state or regional permits, they have to have approval of a comprehensive zoning exemption in hand by March 1st, 2026. So what do you need to do that to accomplish that feat in time to actually be able to meet these deadlines? So first, for a zoning exemption, you need to demonstrate that you're a public service corporation. This should be a lot easier now that the department and the EFSB have determined that storage facilities qualify as public service corporations based on the decisions that they rendered in the previous two cases. Also, within the law, after a certain date, public service corporation will be considered to, storage facilities will be considered to be public service corporations. Second, you're going to need to evaluate what individual local zoning bylaws are in effect that could impede your project, and you've got to provide that list to the deciding agency, which is either, depending on how you read this, EFSB or the DPU. And third, you need to commence studies about the environmental concerns where you're going to locate your project. So for example, you're going to need noise studies, you're going to need to discuss emissions, visual impacts, wetlands, endangered species in the area, your MEPA application if it's warranted. All of those studies are going to be necessary and should really be started as soon as you can if you intend to file for a comprehensive zoning exemption in time for it to be approved by March 1st, 2026, so that you're eligible to file for a certificate of environmental impact and public interest at the EFSB. And fourth, you need to begin your outreach with the locals. So once you have a design plan, you should present it to the town. You got to meet with the police, you got to meet with the fire departments, you got to start to lay the groundwork for working with the town and or demonstrating that the town will not cooperate with you. Either one is fine, but you need to present that you've done the outreach that's necessary, and you need to present that to the DPU or the EFSB, wherever we're filing. And so this is going to take time. And if you need to have your studies complete in time to file a zoning exemption at the DPU or the EFSB, you're going to need to file that by March or April 2025 so that you've got your certificate in hand, your zone exemption approval in hand by March 1st, 2026. As I'm saying all this, it sounds awfully complicated, but there's a method to our madness. And next slide, I think Dan is going to delve into details about this slide, but on a state level, we've already discussed the need for comprehensive zone exemption. At this point, you also need to file for approval to construct a transmission line. The parameters for state approval of that certificate is very similar to what you're going to need to demonstrate for a zoning exemption. So it makes sense to do it all at the same time. MIPA, the Mass Historical Commission approvals, if required, should also be done at the same time so that when you get to the EFSB between March and July of 2026, you have everything you need in hand for the EFSB to evaluate and make their decision. And I will pass it along to Dan.
I should start by unmuting myself.
Yeah.
Thank you, Andrew, and welcome to everybody, and thank you for joining us. It's nice to look at the list of attendees and recognize an awful lot of names, some of whom I've not talked to in some time, but it's nice to see you there. So I'm going to talk about what you do after you get your zoning exemption filed, because you are by no means done under the new legislation. In order to file for the Certificate of Environmental Impact and Public Interest, or a CEPI, as we've been calling it, and I'm sure we'll figure out another acronym for it, you then have to, or at least we are recommending that you start going after your local and state permits, so that you either have them or you can demonstrate that you can't get them when you go into EFSB for the certificate. The statute in the requirements for qualifying for CEPI are found in section 118 of the new legislation, but it provides 6 different reasons, 6 bases, if you will, for upon which the EFSB can issue a certificate of environmental impact and public interest. And that certificate will override all state and local permits. So the statutory intention here is for this process to be in place for only a short time, only until July 1st, 2026. But if the, as Andrew calls it, the EFSB 2.0 regs are not done by then, this process could remain in place in the interim until the regs are done. Again, in order to qualify for CEPI, the applicant will have to demonstrate that it could not obtain the state and local permits and approvals necessary for the project. How do you do that? There are 6 different reasons. I'm going to go into 3 or 4 of them a little bit. If we have time, we can always drill down more on some of the others, because it does get a little wonky. The first one is that the applicant is unable to meet standards imposed by a state or local agency with commercially available equipment. This allows EFSB to override a state or more likely local standard that cannot reasonably met with existing available equipment. This gets at those conditions that are often found in municipal permits that impose unmeetable technical standards for things like noise, light, access, stormwater collection, or any other condition that is imposed really to make the project uneconomic, and it can't be met on a commercially reasonable standard. But remember, again, and I'll keep coming back to this, how do you show that a local condition is unreasonable? You have to go and get the permit or get a denial or have some sort of documentation that shows why it's unreasonable. Number 2 is a state or local permit has been unduly delayed. you know, I recognize, you know, a lot of the people on the webinar have been through the permitting process in Massachusetts, so they will appreciate that it does not go fast. Under our laws, you know, agencies, local and state, are required to open hearings and permit applications, usually within a specific amount of time after the materials are submitted. But then there's no, in many cases, there's no time in which they are required to act. And we all know, and it's difficult, you know, in many municipalities. You know, a zoning board meets once a month. You've got to have a quorum. You've got to have the same people there every time. And for large, complicated projects like large energy storage, it can be difficult to get through those processes in a timely manner, even when there is cooperation. So this addresses that standard. Number 3, and I didn't write it down in my notes, so bear with me. It's inconsistencies among resource permits issued by state and local agencies. This gets to our statement on the side. I'm sorry, this gets to the classic example of a municipality, and I'll give you a very specific example because many people are familiar with this. The municipality has a local wetlands bylaw. Under that local wetlands bylaw, the applicant cannot comply with the requirements. For example, and this is a very classic one, the local wetlands bylaw imposes a 50-foot no build zone within, you know, adjacent to wetland resource areas. You have a project, the only access to it is through a wetlands. So you need some amount of wetlands filling, which is fully permissible under state law, but not permissible under municipal law. So there's an inconsistency among the resource permits issued by state and local agencies. This might be the, you know, in my experience, I think the rest of the panelists will agree, having diligence probably 20 to 25 different BESS projects. This is the one that trips us up the most. You look at the wetlands bylaw and you realize we can't comply with this. Now, I want to make a point here a little different than what I've been saying previously. If you can't comply with a bylaw, then in my view, you don't have to apply. It's much like the situation where you can't get a zoning permit because a battery storage system is not an allowed use in that municipality, so you have to go for a zoning exemption. Here, I think what you would have to show the EFSB is simply that your project cannot comply with the local wetlands bylaw and move on from there. And I apologize. One of the vagaries of our new phone system is it jumps in when we are on Zooms. We're trying to fix that. The next one are permit denials, and the next 2, permit denials and permit delays. You know, they speak for themselves if permits are denied or delayed, and the delays are, you know, because of litigation. Then you can't get the permits that you need, and you'd be eligible to go to the EFSB. Other things in addition to permits that you're going to want to think about, because the FSB is going to be asking you about them in connection with the certificate, are things like host community agreements, pilot agreements, lease and easement agreements, and then our favorite, which we see very frequently on battery storage projects, is making sure that the Chapter 61, 61A, and 61B liens that are applicable to agricultural, forestry, and recreational land. This is a lien that is placed on land put into those categories in order to reduce the property taxes. That lien creates a right of first refusal in the town to purchase the property when it's converted to a different use. Those should have long since been dealt with and terminated before you get to the EFSB. I'm now going to, if you go to the next slide, please. Okay, so now we're going to move on to the so-called EFSB 2.0, and Tess is going to take it from here.
Okay, thank you, Dan. Good afternoon, everyone. So we wanted to talk today a little bit about what happens if you don't meet those deadlines, or if for one reason or another you opt to wait until the EFSB has promulgated its regulations, and you go in for the consolidated permit process. So, as we've stated earlier in this presentation, the EFSB is instructed in the new legislation in the Siting Act to promulgate new regulations by March 1st of 2026, which are supposed to take effect on July 1st of 2026. We, for the time being, are assuming that the EFSB will meet those deadlines, but keep in mind that there is a possibility that they will not. Once the regulations are promulgated and they take effect, all large clean energy infrastructure facilities must, absolutely must, obtain a consolidated permit from the EFSB. So this is correcting what the issue that Andrew raised earlier with earlier projects, which the EFSB determined that were not facilities under their jurisdiction. And so they determined that they did not need a permit from the EFSB. So now all of these projects will need permits from the EFSB. Large clean energy infrastructure facilities are not just BESS projects. That includes energy generation facilities, that includes energy storage facilities, and transmission and distribution infrastructure facilities. So that's a broad range of facilities. For storage projects, that's projects that are over 100 megawatt hours. For energy generation projects, that's projects over 25 megawatts. The consolidated permit will include all municipal, regional, and state permits and approvals, and it will be a composite of all permits. And this is a really big deal because this also includes MEPA. So this includes all those processes that right now you have to go through step by step, piece by piece. It will just all be in one proceeding. Keep in mind as well that they were sure to include regional permits as well. So this also includes regional planning authorities like the Cape Cod Commission and the Martha's Vineyard Commission. By July of 2026, the EFSB is instructed to establish a uniform set of standards and a common standard application for these projects. They will establish pre-filing requirements, which we anticipate will be extensive based on the legislation. These pre-filing requirements will require that developers meet with the MEPA office and all of the other agencies from which they would ordinarily need to receive permits. And they will also have to engage in extensive public outreach ahead of time. Keep in mind that if you're in an environmental justice community, that will likely include additional public outreach that must be done very carefully in a way that I don't know if you can hear the train going by, but you have to do this in a way that makes sure that if there's a population that is non-English speaking, that you provide information and materials in those different languages. The EFSB will be establishing a site suitability criteria and cumulative impacts framework for environmental justice communities. So again, a big portion of this Siting Act, a lot of the purpose of this act was to increase participation by environmental justice communities in order to ensure that these projects don't further exacerbate burdens that are experienced by these environmental justice communities. So finally, the EFSB will have to draft standard permit conditions and requirements. If we can actually move on to the next slide, I'll explain that a little bit more. Can you move on to the next slide? Is it?
You might need to click back into the slide to get it to go forward. Just see if that works first.
Sorry about technical difficulties here, but my screen is showing slide 8. Are you guys still on slide 7?
We are still on slide 7.
Yep.
Great.
No worries. I can try sharing my slides if you would like me to.
Yeah, how about we go for that?
Sure, let me open that up real quick.
Yep.
Sorry for the delay, everyone.
While we're waiting, we did get a question that asks what projects would need a zoning exemption? So if your project can't be constructed due to existing zoning bylaws, that would impede on your project. And you can demonstrate the things that we had mentioned earlier in the slides, such as that you're a public service corporation, that your project is needed, and that you can mitigate or alleviate some of the environmental concerns. You can then get a zoning exemption. The other reason why that's whether or not if you want an EFSB process or not. If you do need to go to the EFSB under EFSB 1.0, the current one, and that's the one that you need to get to by March 1st of 2026-ish. If you need, then you will need a comprehensive zone exemption in hand to do that. So I'm sorry, Tess, I just figured while we're waiting,
no
I'd
problem.
answer some of the questions. Thanks.
Nope, not at all. So then when we're back in the EFSB 2.0 land, so the EFSB will be generating standard permit conditions and requirements. And that is because the EFSB must make a determination on an application once it is complete within 15 months. And otherwise, if the EFSB does not make a decision within 15 months, then an approval will issue containing those common conditions they've established in the regulations. So we will be keeping a close eye on those regulations to see what those common conditions would be. I'm sure we'll issue a client alert when the time comes for that. But keep in mind that when you file an application with the EFSB, they will have 30 days after the filing to determine if the application is complete. And if not, there will be a 30-day period to cure. But that means that the 15-month clock will not start until after the EFSB determines that your application is complete. So there will be, if you add in those two 30-day periods, it'll be really more like a 17-month process. And then if you add in the pre-filing requirements, that bumps you up even more. So that will take additional time. So as previously mentioned, the consolidated permit, when issued, will be in the form of a composite of all the individual permits, approvals, and authorizations that would otherwise be necessary for the project. So that will if you needed a special permit for this project, then a special permit will be part of this consolidated permit. If you needed a MEPA certificate, that will be part of the consolidated permit. Interestingly, the EFSB will, under the Siting Act, the EFSB will not be enforcing this consolidated permit. Instead, all those municipal, regional, and state agencies that would otherwise issue those permits will be responsible for enforcing those permits. So while some maybe envision this act as providing a way to sort of bypass all of these local, regional, and state agencies, it does not give developers carte blanche to really bulldoze over the interests of these municipal and regional agencies. You really need to start working early on to establish relationships and make sure that you are responding to their concerns. And additionally, all of these agencies will have automatic intervener status in this consolidated permit process. So for some of these projects, this is going to be a very crowded room. You could have MEPA in the room, you could have local planning board, zoning board, conservation commissions, you could have a regional planning commission, and they will all have their own interests, they will all have their own concerns. And luckily, this process will be capped to 15 months, so that should keep things moving along. But just keep in mind that once you're in that 15-month process, you will be kept probably very busy. So with all that said, this gives you some information about what you're going to be facing if you wait for EFSB 2.0. It's not going to be a silver bullet. It's not going to be the easiest one-stop shop, but it will at least consolidate all of these various proceedings into one. And at the end of the day, after 15 months, a permit will issue one way or the other.
So Tess, I'll interrupt. We've got a number of questions that came in. Will the muni, regional, and state agencies be able to provide input on special conditions? And I believe the answer to that will be yes.
Yes.
When those folks will be interveners in the case at the EFSB, and as interveners, they can make their special conditions what's known. The plus side is if you're unable to meet those conditions, this provides you an opportunity to state so on the record and have the EFSB decide that those conditions may be unreasonable or unworkable. We also have another question: does it make sense to apply to the DPU for a zoning exemption after April 2025, or just wait for EFSB 2.0? And I think the answer to that is, as soon as you can have all of your studies in place, if you can do that, the April 2025 date or the March 2025 date was basically working backwards from when you need to have your comprehensive zoning exemption in hand at the in order to go to the EFSB. We've been saying it takes about a year. If you can get it in 9 months or something like that, it certainly is worth the try. The downside to wait to EFSB 2.0 is, one, the regulations have to be in place, and who knows if they're really going to be able to meet this deadline. I know they're trying, but I'm not sure that, given the number of agencies that have to participate and then the public process that one has to go through in order to implement the new regs, that could take quite a while. So there's a question as to what this new EFSB is going to look like and when it's going to become in place. And you have 15 months. Once it becomes implemented, they can issue their decision, I believe, within 15 months. But the 15 months starts at some date in the future. So whatever folks can do to get into the current process, we know what the EFSB is going to be looking at under the current process because they have lots of precedent for this. We're not sure what they're going to be looking at under EFSB 2.0. So anything that you can do to get to the DPU or the EFSB with a zoning exemption as quickly as you can prior to March 1st, 2026, so that you have a better shot of having this in hand, an approval in hand. That's what you should do. And those are the questions we've got so far.
There's also one other question buried in there as well about whether the EFSB 2.0, whether you need to have a DPU zoning exemption before filing for that application. And the answer is no. And in fact, under section 118 of the new law, it states that if developer has already filed for a transmission approval or a DPU zoning exemption or any other local permit or approval before July 1st of 2026, you do not need to go file for a consolidated permit. You are actually exempt from that process. And I suppose that you could go back through that process if you wanted to, if you had a zoning exemption, but you wanted to wanted the EFSB to issue a permit to override the remaining local permit requirements, you could go through the consolidated permit process after getting a zoning exemption. But you might want to ask some harder questions about what your timeline is for your project and whether that makes sense at that point. But you do not need a DPU zoning exemption before going through the 2.0 process. You just need the zoning exemption for the CEPI, which is separate from the consolidated permit process.
And we have another question that basically is saying, given that you need to be out of the zoning exemption process by March 2026, and that process takes a year, I'd have to file for a zoning exemption on March 1st, 2025. That's effectively 3 months from today. So what do I have to do to complete in 3 months? And what's the time lead to do that? And I think that the answer to that question is that it is doable. You would need to retain your consultants that are going to be looking at, as we had mentioned earlier, some of the noise study, wetlands, stormwater. There is lead time to do all that. It's a few months. So obviously the March 1st, 2025 or April 1st, 2025 deadline that we're talking about is, ideal. It gives the DPU or the EFSB a full year to make a decision on your zoning exemption. I do believe that the DPU or the zoning or the EFSB, wherever we've got to go, does understand that they're going to be getting a significant number of these cases in order that will need to be decided by within a year or within 9 months. And I would hope and presume that they are working on making sure that that happens, so that companies that are intending to go into the EFSB 1.0, there's an ability to do that, and it's not just going to be held up because the DPU or the EFSB couldn't get their act together in time to issue an approval for a zone exemption or a decision.
All right, and I think with that, we'll move on to our last slide with Nick.
Yeah, sounds good. So just as a general note, we really appreciate the audience sending in your questions. And for the next 10 minutes after this slide, we are going to kind of open it up to all of you just to keep on asking us, some questions or providing comments on the new legislation. So we will turn back to that. But we just thought that it would be prudent to point out some of the other provisions in this bill. As Andrew was saying earlier in the presentation, this is a very comprehensive piece of legislation, and there's a ton built into it to facilitate clean energy infrastructure in the Commonwealth. As you can see from the list in this slide, it really spans the gamut from creating an Office of Environmental Justice and Equity to helping the rollout of EVs in Massachusetts. I'm not going to go through each and every one of these points right now, but we did want to flag for this group in this audience, who most of you might be energy storage developers, 2 provisions in this act that we're not really diving into today. The first is the fact that there's going to be an energy procurement for energy storage. The Commonwealth has set forth a goal of 5,000 megawatts for long-term contracts for energy storage. So 5,000 megawatts is not a small number by any amount. And the Commonwealth is really gearing their procurement goals towards long and multi-day duration storage, with a carve out for 3,500 megawatts for batteries over 4 hours in duration, 750 megawatts for batteries over 10 hours in duration, and another 750 megawatts for multi-day storage batteries. The second aspect of this bill that we wanted to point out, besides the citing for projects, is the fact that the act requires state officials to establish a site suitability criteria, and these criteria are really geared toward helping developers select sites and state officials to evaluate projects, and they're going to be developed with with an eye towards mitigating the social and environmental impacts generally associated with these large clean energy projects, including energy storage projects. So you could imagine that might take into account environmental justice communities in the area. It could take into account the noise that's associated with the project based on the neighborhood that it's in. It's unclear what is going to be included in this criteria at this point, but it's something that every developer and potentially utilities should have keep an eye out for. And if you have any questions about that, please feel free to come around and ask us about that after this webinar. We also plan on having more webinars like this one in the future where we go over some of these provisions as they evolve. But for now, I'm going to turn it back to Dan, Andrew, and Tess, and we're going to keep going through some of these questions that we're getting in the citing processes. So I guess we can just flip through the next slide.
So one of the questions are, so what is the biggest hurdle in the interim process? I can start. I think the biggest hurdles is the need for studies and the fact that there's really a lot to do in Q1 of 2025 in order for you to meet these deadlines. If you have your site chosen, if you've got your financing in place, if you're pretty sure that you're ready to go with this project, and your consultants are able to at least start most of the studies and we're able to put together enough of a case to go for a zone exemption to the DPU or the EFSB, depending on where we wind up having to go, then you will have met the biggest, what I would consider to be a hurdle, but I think timing is the biggest issue. The same person asked, so what's the biggest hurdle in the new process? And I think the new process, the hurdles are sort of the unknown. The law requires a lot of different regulations to be in place by July 1st of 2020. They need to be promulgated by March 1st. They need to be effective by July 1st of 2026. That is a lot to do. There's a lot of constituents. There's a lot of people with various experiences that want these regs to say many different things. And the law spells out a rather broad process in order to make sure that the regs are implemented in time. So I think at that point would be amongst the first of the large battery storage projects to fall under the new regs, and that's always a risk. So if you are able to sort of condense the process of filing for a zoning exemption prior to, or at least sometime in the beginning or a half of 2025, I think you're probably better off doing that. The downside to that, I think, is better than the downside to waiting for EFSB 2.0, but that's just a personal opinion. Dan
Andrew,
looks like he wants to say something.
Yeah, I'm just going to jump in on the question, the biggest hurdles in the interim process. And I completely, we've talked about this a lot internally, and it's, getting going on the studies. People are in different stages on that. But if you've got a MEPA trigger, you've got MEPA filings. And if you're within a mile of an EJ population, you're mandated for an environmental impact report. As Andrew says, the first step is to get that zoning exemption filed. And what I want to mention is that if you want to go on the interim process, there is a lot of overlap with the studies that you're going to need for your zoning exemption, for MEPA, and for your local permits. So what I'd recommend is that when you're contracting with your consultants on, contract with them thinking about the whole process rather than trying to do it piecemeal.
Another question, if a developer came to you today with a new project but no permit work in hand, what would you tell them to do in the next few days? And I think that what we've been trying to say today is in the next few days, I think you really need to sit down with a consultant that does environmental studies and work with a noise person and see how far you are from residences and where the property lines are from your battery project. I would take a look at the zoning bylaws and the locality that you're looking to work in. Does it allow a BESS at all? If it does, what are the parameters? Are there height restrictions? Are there noise restrictions? Are there wetlands restrictions? Are there setbacks? And start to put together a list of those zoning bylaws that you can either work with or you can't work with, and that would go into the zoning exemption. Dan, did you want to add?
Yeah, I mean, to add to that, put on the real estate hat, title and
Yes.
survey.
Yeah.
You know, a lot of these sites are country title, what we call country titles. You know, they're not inside of I-95. So the title can have all sorts of things on it that are old and may take some time to get resolved, or one in particular we looked at some time ago. It came in and we were going to diligence the whole project, but the title came in first and there was a big permanent restriction that said no commercial uses. So the good news there was we caught it very early and the client did not have a big bill. The bad news is they didn't have a project either. So.
And I would also point out, yeah, making sure along with the title, you want to check and make sure, especially if you're outside of 95 or 495, seeing if the property is subject to chapter 61, 61A or 61B, because the process of withdrawing from that program is not easy and has to be done very carefully. And that can also derail a project if it goes awry.
Thanks, Tess. We have another question. Any more insights into what can be expected for the rulemaking process regarding consolidated permitting? Should we just wait for the EFSB to propose a draft rule for comment? So I do not believe that the EFSB intends to just draft a proposed rule for comment. I believe that the thought process, at least now, is to sort of take the show on the road a little bit and get input from various constituencies on what would need to be in the draft, in a rule, a final rule. And at that point, the EFSB, DER, the DPU, whoever is responsible for drafting the regulations, would in theory take those notes and put together a proposed draft for folks to comment on. So if you are wanting to sort of, now the other question is, and this is a tricky part to how it's written. The regs have to be promulgated by March 1st, 2026, but the statute that allows the EFSB and the DPU and DER to start doing all this, there's some question as to when that actually kicks in. But let's presume they're going to resolve that issue and it kicks in pretty much immediately. There probably is some kind of a process. It probably is more of a lobbying and in meeting with folks and trying to see where they're at and getting your comments in as to what a proposed rule might look like. But after that sort of informal process, the more formal process will be that someone's going to issue formal regulations, and there should be an opportunity for folks to comment on that before they go into before final regs are published and they go into effect, which in theory should be either March 1st or July 1st, 2026.
Andrew, there's a question on the 61A process and how long does it take? I'd suggest that Tess take that one.
Okay. Thank you, Tess.
So as mentioned earlier in the presentation, so Chapter 61A is a tax benefit program in Massachusetts whereby So 61A in particular is for agricultural land. 61B is for, I think it's 61B is forestry and 61 is forestry, and one of them is recreation.
61 is forestry, 61A is agriculture, 61B is recreation.
Yes. We mostly see 61A. And landowner who has land that's recreational or forestry or agricultural land, they don't want to pay full taxes on highest and best use. So what they do is they file into this program in order to get their tax rate aligned with the actual use of the property. But the catch is that when they withdraw the property from that program, or they convert the use of the property to a different use other than what it is in, the town has a right of first refusal to purchase that land. And it's not just triggered when you sell the property, it's also triggered when you lease the property for another use. So if you've entered into if you've already signed a lease agreement, for example, in order to use the property for battery energy storage, that likely triggers the conversion requirement there. And as soon as you convert the property, you need to notify the town that you intend to convert the property, and then they have a right to purchase the land. Either if you're buying the land, either they can buy the land at that same price that you're buying it for, or if you're leasing the land, then they have to get they have to appraise the property within 30 days and then pay you based on what that appraisal amount comes in. So this process to withdraw takes, I would say, it depends upon whether the town wants to buy the land. It depends on whether the town wants to, they can also assign their right to purchase to a nonprofit. So if they are motivated to acquire this land, then you could be looking at, 30 to, I think, 120 days before you have a resolution of that process. If the town is uninterested in the process and they've, kind of moved through it quickly, I would say it's 30 to 60 days. But it's something you really can't sleep on, because if you send your notice to the town that you're going to convert this land and they've decided that they want it, then they can come in and they can scoop it out underneath you, or worse, they can assign the right to purchase the land to a well-funded nonprofit that can then scoop it out from underneath you. So that's why we tend to flag it early on in our diligence reviews.
Just to jump in on that, this is something that, not surprisingly, it's a kind of a unique Massachusetts thing. It never gets flagged by in-house counsel or by National Real Estate Council. It may get flagged that it's there, but there's never really any understanding that it's a right of first refusal in the municipality.
Any other questions?
Andrew, we had a couple of people ask for a recording. We're happy to provide the recording. Maybe the easiest thing is just to send it to everybody that's on the list.
Works for me. And I'm sure I know how to do that. So
the marketing group is on
yes.
line.
Will do.
I'd say it's the final, to like kind of go back to something we were talking about a couple minutes ago about, if somebody comes to you and they don't have their permits yet and they ask, what do you want to do first? It's really important to make sure that you have good local counsel and good local or, locally competent environmental attorneys and consultants who can tell you what the local bylaws are going to require of your project. Something that zoning can be nuanced and difficult, but then there are also local bylaws that can be nuanced and difficult. And you really need to know what is going to be required of your project at the get-go in order to understand which of these processes you want to undergo. Like, that's going to guide your decision-making about whether you're going to go for a zoning exemption, whether you need to go get a CEPI at all, or, whether it makes sense to just wait for the EFSB 2.0. You really do have to get going. If you've got a site in mind, you really have to get going and really take a close look at what your project is going to require, from start to finish.
We are happy to help with that.
I'm
assuming that Tess meant us when she said.
The other thing we often see is, a lot of this stuff is under option. And we look at the options from a real estate lens, and we often see some things that we need to get cleaned up, either to comply with Massachusetts law or just to make sure the battery storage developer is going to have all the rights that they need going forward from a real estate perspective.
Mm-hmm.
Very good.
Yeah,
well,
some other real estate pitfalls that you've seen in some of these projects.
I mean, the classic, many, of the battery storage developers, they'll have a standard memorandum of option. It doesn't match, a standard option agreement memorandum of option to record. And a lot of times they don't match up with Massachusetts law. So we've actually developed some standard forms that do comply with Massachusetts law for a couple of clients. The title one is always bad. I mean, one of the things we see standard title is 50 years. Sometimes you want to go back a little further, especially in some of these country titles, because you might have a 100-year-old easement that's not showing up.
So as we end today, we do want to thank you all for participating. We appreciated all of your questions. We certainly appreciated you listening in, and we are happy to continue to talk through any projects that you have or any thoughts you have about next steps for your particular project. Just give one of us a call. Our contact info is on this slide, and we will end. So thank you so much. We really appreciate it.